Good morning and welcome to the UK Adjudicators Adjudication Arbitration Conference London 2022. I want to start, as I hope you would expect me to, by paying tribute to Sean Gibbs for the excellent concept that he has developed and for the characteristic energy and enthusiasm which he has adopted in implementing it. It is a first-class performance on paper. We're going to see how it turns out. But now you've done your bit. You've got them all here, you've got the audience here, and you've got the panels here, well, most of them anyway, can't have everything. You've got the venue works, the food was lovely, the people are largely here, old friendships renewed, new friendships made. So if I may say so, Sean, a shout out to you for a job, at least so far, well done. What's that great line? He who can does. He who can't teaches. He who can't teach teaches teachers. I think that's the approach that Sean's adopted with me. He who can does. He who can't chair. He who can't chairs. He who can't chair chairs the chairs. Now, it's my great privilege to introduce today. I'll be around, I hope, during the day, though I give a disclosure in advance. I had my COVID booster yesterday, so if you see me sort of snoozing in a corner or not here, don't be at all surprised. But it's my job to introduce today, and I'm going to do, if I may say so, two things. One is I'm going to give, I hope, some context to the importance of this event and its nature. And secondly, I'm then going to tell you just a little bit, very, very briefly, about what's going to be happening during the day. Context. We now know that adjudication is now very much part of our fabric. I was at a 39 Essex Singapore party at the weekend, and we were talking to our colleagues in Singapore about adjudication and the effect on domestic construction arbitration and how adjudication had worked and whether it was accepted. And as we explained to them how it was now, whilst it was statutory, it was the dispute resolution method of choice, and that it very nearly always produced an outcome, and it wasn't simply the starter of the menu for the long proceedings to come, and the sort of slightly wide-eyed approach of, is that really right? And we explained it. And it made me reflect, and I know that we had the 25th anniversary of the Act and therefore the opportunity for sort of formal reflection, but adjudication has been a remarkable success. And one of the reasons for that, I think we could all trace a whole package. Obviously, one of the reasons for that, the context is that the judges have been very supportive of adjudication and have enforced it. But secondly, the other, and that's been a great help. But secondly, the key, and I think Lord Justice Coulson's made this point in several judgments, is the quality of the adjudication community in terms of its technical knowledge of the way in which adjudication works, its wisdom in the decisions that it makes. And that without that community coming together, it seems to me, and I'm sure many of you, I'm sure, would agree, that it's that quality that means that the industry can have the confidence that it does in the process and the people. Now, how has that confidence arisen? Because let's be candid about it. When I said this once at a conference, I got a solicitor's letter from an arbitrator. The construction arbitrators community, before adjudication, did not enjoy the confidence. You know, John's laughing. Perhaps he acted for the solicitor why I got myself into such trouble, and those of you who know me will find this difficult to believe, was I actually was foolish enough to mention the appointing body that was responsible for the worst appointments. I shan't make any reference to the RICS because that would be quite wrong. In those days, construction adjudication was a real problem, and it was not. And the quality of the dispute resolvers, I remember when I was interviewed for my pupillage by John Blackburn, QC, KC, QC as was, KC as is now, and I'd been in a shipping pupillage to start with, and he said the one thing you're going to find is that the arbitrators in shipping are marvellous, and the arbitrators in construction are rubbish. Now, so what's so fascinating is that with that background, over the years, this high-quality, highly regarded cadre cohort of adjudicators has developed. And the answer, and you'll see where this is going, why? The answer is events like this. And it seems to me that the way in which the industry, the adjudication industry, has reacted to adjudication by standard-raising events, accreditation, training, articles, societies, newsletters, on and on and on. That has been what has been the key to it. But it's more than that. And here I am, a slightly sensitive ground, I know, from time to time, but it's also the peer pressure for quality and good behaviour. Now, we know that doesn't always work, and when it doesn't work from time to time, we know that the industry comes together to try and move it on to the next step. And I think that has been traditionally very successful. But these sort of community events are, in my judgment, a critical part of that evolution. And that is why you end up with training that is why it's so important to have the quality of training. Now, it's also important, and this segues into today's event, to have a, segues into this event, to have a diverse, and I mean diverse in subject terms, methods of training. You don't simply train how the referral works, natural justice, and that you do actually push yourselves, and are pushed by Sean, into new and innovative training so that that knowledge bank spreads. Now, today you've got 6 panels, and the first panel, who are sitting in front of you, will be dealing with sole or multiple decision makers, what's best. That'll be an interesting talk, I'm sure, an interesting seminar. My good friend Jeremy Nicholson and I spent 10 years fighting a case together. Difficult to believe that you'd fight a case for may have been longer than 10 years. But certainly it was a very long time, where Panatown and McAlpine for probably half the rest of you were in it. But that's the sort of case that now wouldn't survive adjudication. It might have been got over in 5 years rather than 10. So this panel will talk about sole or multiple decision makers. Then there'll be why adjudicate, and the mode's going to be a panel of 4 chaired by a distinguished chairman. Then consideration of why one should go to adjudication first as part of dispute resolution. Then a session about dispute boards and why they work. Then lunch. Very clever of Sean to try and take time-telling measures to avoid the dead slot so that everyone's asleep, so that they'll still be awake for the immediately after lunch slot. There's nothing worse than speaking in the after lunch slot. But today it should be all right because it'll be very early. Governing laws, issues in tribunals, so taking it one further step forward. Then the 5th panel, which I hope I'll be still here for, bearing in mind my COVID, experts, COVID jab, experts and lawyers' views on international arbitration, which I think will be a particularly interesting session. And then finally, and this makes the point and enables me to finish off on the point I started on, needed improvements in adjudication and arbitration. And that, for me, reflects the process that this conference is such an important part of. It is inward looking to train us, outward looking, though, to see how we can improve that which we provide by way of service for the industry. So welcome to all of you. Welcome to the panel. I hope everyone has a very good day. Thank you very much indeed.
Well, thank you, Paul, and I'm delighted to see that so far, at least, the COVID booster vaccination seems to have boosted your energy levels rather than slowed you down. So, to this session. 1, loneliness. 2's company. 3's a crowd. So which one of those numbers works best when it comes to people deciding construction disputes? And especially if you get the chance to specify that in the contract documents. or even, very rarely, to agree it after a dispute has surfaced. Well, 2 has never been popular because 2 people, one appointed by each party, might just disagree. What a surprise. In shipping and commodity arbitration clauses, it used to be specified sometimes with provision for an umpire to decide between the 2 party-appointed arbitrators if there was disagreement. But I understand that no longer happens and hasn't happened for quite some time. And in construction contracts, it has never featured, so far as I'm aware. So we can swiftly pass on from 2 as a serious option. One person deciding is the most frequent approach in the UK, as you all know, and also in common law jurisdictions overseas. And that applies to both litigation and adjudication and arbitration, although there's not much of that going on in UK construction at the moment. So why one person? Well, the main reason, I think, is that in the UK we have a touching faith that one person is going to reach the right decision and is not going to go barking down the wrong rabbit hole, something we've never seen with adjudicators or judges or arbitrators, of course. And we also allow very little scope for setting aside decisions, especially in litigation and arbitration. And in relation to adjudication, of course, the decision is generally binding, at least on a temporary basis, and in practice is rarely the subject of an application or action to correct. And of course, one-person decision-making does have powerful advantages in terms of, first, speed, and secondly, costs. For example, in relation to speed, if you had the sort of timescales for adjudication that are typical in Australia, it would be almost impossible to have the decision maker other than one person. Now, in contrast, 3 persons is the typical approach overseas in civil law jurisdictions and in international construction projects. And that may well stem from scepticism that one person on his or her own is going to reach the right decision. So in the German courts, for example, any civil dispute over 5,000 euros in value is likely to end up in front of 3 judges, something that just doesn't happen in the UK outside at least certain tribunals, but never at first instance in the civil court system. In construction arbitrations, the norm is 3 arbitrators, not invariable, but usually. And in construction projects with provision for dispute boards, typically large infrastructure projects under FIDIC conditions, the norm is 3 DB members. And there are a number of advantages. First, 3 heads are better than 1. It's often a good idea to talk with other people before you make a decision, as our latest ex-Prime Minister found out. Secondly, it does share the workload of writing awards or decisions, which can be quite heavy, particularly if one has a DB which ends up with effectively a final account sort of a dispute. Same applies in arbitration. Thirdly, it does give the opportunity to select people best suited to the dispute. So, for example, on DBs, there's the opportunity for complementary expertise, and typically at the start of a project, the parties might aim for a dream team of an engineer, a QS, and a lawyer. And for a standing board, when one doesn't know what type of disputes are going to come down the pipeline, that's really quite a useful approach. So, in summary, those are the issues we're going to dive into in rather more detail in this session. Let me tell you something about our panel, and doing the diving into the issues will be 3 and hopefully in a moment 4 great panellists, each specialising in construction and engineering and able to speak from a huge amount of practical experience of dispute resolution over many years. So in order of appearance, we have John Miller, partner at Fenwick, Elliott. He started at the sharp end of the industry in M&E engineering work before becoming a solicitor. His practice includes both dispute resolution and transactional work, and he's now had more than 100 appointments as an adjudicator, and he also acts as mediator and arbitrator. And he will be followed by Richard Bailey, also a solicitor with a practice divided between dispute resolution and transactional. He is a partner and head of construction and engineering at Druces, well known to many of us in this room from his years of sterling work for Society of Construction Law UK as treasurer and then chairman. Then Seamus O'Doherty, chartered quantity surveyor and chartered builder. He has experience from both the contracting side and the professional side of very many projects worldwide. He's now director in Berkeley Research Group's construction practice, giving expert advice and evidence on quantum. He also sits as an adjudicator and an arbitrator. And finally, the temporarily absent Damian James, but eagerly awaited, also a quantum expert with a particular expertise in delay analysis and disruption valuation and disentangling global claims. He also sits as an adjudicator and arbitrator. As described by one grateful client, claims consultant, great guy, expensive, but will do the work in half the time. What's not to like? And I imagine he's polishing something off at this very moment on his way here. So let me also tell you a little more about where we're going on this. What our panellists will be focusing on is this. So John is going to start by focusing on one-person determination, and in particular from the UK viewpoint. Then Richard will also focus on one-person determination, but from the UK and also broadening that to an international perspective. Seamus is going to move us on to three-person determination from the international viewpoint. And last, Damian is going to talk about three-person determination, again from the international viewpoint and with particular focus on dispute boards and indeed practical experience in Africa. So that's what we have in store for you. Over to John.
Thank you for the introduction. Let's see if I tap that. Oh, slides? No slides, thank you. Okay. John Miller, Fenwick, Elliott. You've heard that I act as adjudicator, but I also sit and act as advocates in front of adjudicators as well. So I'm just going to take you through in 8 minutes the pros and cons of using one dispute resolver to resolve disputes, and I'm sure most of you have got your own ideas. The first point that sprung to mind for me is it's cheaper. A single dispute resolver should be far cheaper than having a panel of 3. And the very last thing I'll deal with, does it really matter? because the point being is, in the UK, we've decided it's one dispute resolver who's going to deal with it at the first instance. It's normally adjudication, and it's far cheaper than a panel of 3. The parties need to contract into whether they want a panel of 3 to resolve their disputes. It should be quicker as a result. One diary, one person resolving a dispute. Often I find with panels, and I don't do a lot of panel work, just coordinating the 3 people's diaries can take a lot of time and effort via their clerks or otherwise. And just to remind you, Corinne Davenport, and I'm a bit sceptical of this, a statement was made there whereby the industry decided that rather than getting the right answer, the main impetus behind particular adjudication was speed. Okay? So getting the right answer was subrogated to the need to get a quick answer. I, again, am sceptical of people who don't work in the construction industry, including me, saying what the construction industry wants. But speed is seen as one of the big advantages to having one dispute resolver. The other advantage that you often hear is you have some control, not with judges, but with an arbitrator, with an adjudicator. One, you have control over the appointment, who you're going to appoint. And 2, the process. I think that's the theory, but I'm not too sure it's the practice. Every adjudication, every arbitration I have, I always suggest, how about X or Y? And straw poll, about 50% of the time we agree it. And I normally agree to what the other side say if they suggest somebody who seems sensible. But often if you suggest somebody, it seems that there's a hidden agenda there why you want that particular person. And one thing I've got to say is I think times have changed a little bit since the bias cases of a few years ago. Adjudicators are much more alive to bias and are much more willing to declare if they've got an issue with a party or a firm of lawyers or such. I'm currently an adjudicator on a matter where one of my ex-colleagues represents one of the parties, immediately declared it, and they just moved on. It's not an issue. So I find in adjudication as well that very often, once it starts, the parties couldn't even agree whether today was Thursday or not. So it's an idea to agree an adjudicator and agree a process, but the practice may be very different. Also, much is said of the tripartite panels about expertise. You can have a legal chairman, a QS as a wingman or wingwoman, or an engineer. Now, adjudicators, I find again, you have experts. It's very rare to do an adjudication with any sort of technical or financial issue without an expert, often both experts, on both sides. So experts often provide expertise to adjudicators and judges alike. Just one point, if an expert's duty is to the tribunal, to the adjudicator or to the judge above everything else, I'll go back to pre-CPR, why do you need 2 experts? Okay. Prior to the CPR being formalised, there was a big impetus to have one expert appointed by the court. If they both have a duty to the tribunal, not to the person paying them, why should you have an expert on both sides? But that's a debate for another day. Disadvantages. These are my views, not the views of my firm. Very often, and I'm putting my head in the lion's mouth here, the way adjudicators are appointed is a bit cryptic. It has changed quite a bit. We had one of the leading AMBs come to my firm who we felt that the adjudicators being appointed on large disputes, surprisingly, were the people who often gave lectures on behalf of that AMB and explained that they were changing. A more diverse panel, a different panel, and what have you. We still believe that on certain AMBs, if we have a certain type of dispute or a certain value, we can normally come up with 3 or 4 people who are going to be nominated. Okay? And many years ago, there was an organisation called the Umbrella Group. I think it's dissolved long while ago. It was when AMBs got together and held a conference like this. And the point made over and over again is, how are adjudicators appointed? How do you appoint them? And then there were various AMBs that were saying, we're going to be more transparent, subject to the Data Protection Act. I've not seen any transparency going further than that initial conference. There are certain groups that operate a CAB principle, text is very clear, but very often it's difficult to work out exactly how an adjudicator has been appointed or nominated. Another disadvantage with one-man panels and adjudications that we all realise here is hijacking. 28 days is a very fast process, okay? And the complaints are it gives rough justice. I don't think that's a complaint of having just one person, it's a complaint of the speed. Okay? And a point I made earlier, has the industry foregone getting the right answer absolutely right in return for speed of dispute resolution? Again, another criticism levied at the one-man panel is, well, lack of expertise. A big infrastructure project, you can have engineers, QSs, and lawyers sitting together. Okay? That's levied at adjudicators, not normally levied at judges, that particular criticism. But that is an inbuilt advantage in my view. If you can select a panel of 3, you can pick the people or the disciplines that you need to deal with your disputes. The biggest disadvantage that I see in a one-man panel, and again, particularly adjudications, is large disputes. Are they really suited to large disputes? Again, at the beginning of adjudication, when it first came around, there were comments made that, well, hold on, you can't put a really big final account in front of an adjudicator and expect it to be done in 28 days. Okay. Is adjudication really suited for large disputes? I have an adjudication at the moment, it's a final account. We are 3 months in. We had a conference call with the adjudicator yesterday afternoon. He's saying he hasn't read all the papers. He may finish it by next week or the week after, and then he'll give an idea of the timetable, and we've had to accept that. Just a 3-man panel can split the workload. Okay. So there is expertise and issues that crop up there. And finally, my last real point is, does it really matter? Because in the UK, we have statutory one-person adjudication. Okay. If you want to opt out, we can't opt out of it, but if you want an alternative, you have to deal with it at the contract stage or at the dispute stage. But the bottom line here is, in the UK, the default mechanism is it's a one-person panel, a judge, an arbitrator, or an adjudicator if you can't agree those. So it always reverts back to the one person. Okay, that's all I said for now. Richard's going to deal with other issues, particularly internationally.
Thanks, John. Over to Richard.
Okay, good morning. Yes, thank you, John, and thank you, Jeremy. There's rather a lot of overlap between what I'm supposed to say and what John's already said. So let's just take everything John has said as read and just move on. There is one thing I'm going to say, because I had this horrible moment of realisation. The Arbitration Act and the Housing Grants Act, both 1996. 1st of May 98, obviously, with adjudication. And for my sins, I qualified on the 1st of September 98. It's also the year the civil procedure rules came in, for those of us who forget, 98. So it's a big year. But the purpose of this is sole or multiple decision makers. And I know it's an adjudication conference, I know this topic goes wider, but I want to talk about judges first when we're talking about sole decision makers. And bear in mind, the one thing I haven't said, I'm supposed to be speaking from the representative's point of view on this, sole or multiple. But before thinking about whether you have one or more, just a reminder that in the court system, we have one judge who determines incredibly high-value cases at first instance. But ironically, if you go to the Court of Appeal, you will get 3 judges. So you have just pros and cons of things, but just so we remember that when you think about courts and whether 3 or 1 is the right thing. As far as the court is concerned, 1 judge is right to start with, but once you have an issue, an appeal, you go to 3 judges to make a decision. And let's remember just how many there are in the Supreme Court as well as a panel to when it's a very important legal decision. Anyway, what I want to talk about, of course, advantages and disadvantages of a sole decision maker. A lot has been said already about adjudication. comments made about adjudicator nomination bodies. I can see a fair number of adjudicators in this room. Thankfully, I don't wish to receive a solicitor's letter like Paul did, so I'm not going to make comments about any particular adjudicator. But there is always a question when we're looking at appointment, as John's already said, about who you nominate or who is nominated. And it does sometimes appear when we're talking to clients that it's quite a closed shop in some nomination bodies. If it's a high value adjudication, you can guarantee there's going to be a group of maybe 10 who will be on that. There's certain organisations, there's sort of the cab rank principle that's applied by TEXA doesn't seem to apply. You're probably going to get the same people. Is that because it's a safe pair of hands in the view of the nominating body? Certainly you do question. But the worry I usually have when I'm advising clients as we're about to commence adjudicators is actually cost and the quality of the adjudicator that you may receive, have appointed. And so you look at your nominating body in the contract, you're always advising of that. And then, in fact, I remember, because sadly I was at Fenwick Elliott at the time, there was a case that was done about nomination where a firm of solicitors had on the nomination form only listed 3 potential options as the adjudicator. You could see someone in the audience smiling because it was a firm he used to work at that did it. And around bias. So, and it turned out those 3 adjudicators were all known to that firm of solicitors. And there were some question marks raised about bias and around that appointment. And it's that became quite a big issue, but I don't think that's an issue so much today from our point of view. But we do worry, and I've turned round to clients and said, and the adjudicating question is not in this room, as soon as I've received a nomination, oh dear, that's not the language I used, we're going to get one ridiculously big bill for nothing here. Smash and grab adjudications, and you can tell a client at the end when certain adjudicators are nominated, we're about to get a £20,000, £30,000 bill for a smash and grab adjudication. Batten down the hatches, and I'm not going to say any more, but I can see 2 people going, I wonder who he's talking about. But I can think there's a whole audience full of people wondering who I'm talking about. You all know. There's a group. But so that's the problem for us. There's cost is really important. Single panel adjudicator for us when I'm advising clients and who we're going to get and the nominating body and who's on the list. And if we're looking at a contract to see who's been agreed. I still see contracts when I'm doing at the transactional end where they list a small group of adjudicators as the contractual adjudicators. Now, interestingly, it's the same for adjudicators pretty much every time. There's a list of adjudicators in a contract, one of whom's in this room. So put forward, but usually we don't have a problem because they are sensible individuals, so we're quite happy today. So anyway, moving away from adjudication, moving towards the international sphere, but also looking at arbitration. I took the time, and I think Seamus has shown me some notes, so he'll be talking more fully on this topic. So I'll just be an introduction rather than right over his. But I was looking at what do the various arbitration rules provide for the nomination of arbitrators? Do we have any sort of common theme about single or multiple? Because when you're working abroad, it does seem that dispute boards, 3 parties, arbitration, you have each party nominating their arbitrator, and then you have the chair of the arbitral tribunal who's either nominated by the institution or somehow agreed between the parties, and then you begin to feel in some arbitrations that actually 2 out of the 3 arbitrators have been picked almost to be advocates, extra advocates for your client, a sort of view. Of course, that's not my view, so other people's view that these arbitrators are chosen for those purposes. But you do have that with 3. You're always thinking about who is going to be your party nominee. But I looked at the rules. So the CIR arbitration rules, 2015, refer to the possibility of agreeing a single arbitrator, but defaults to 3 in the 2015 rules, whereas the CMAR rules is single arbitrator. And then also, and this is where I'm going to step a tiny bit on Seamus's toes, but I'm just going to reference the LCIA rules, in particular Article 5.8 of the LCIA rules, that refers to a sole arbitrator shall be appointed unless the parties have agreed in writing otherwise, or the LCIA court determines that in circumstances a three-member tribunal is appropriate. And given what Jeremy said, there's an interesting bit in brackets in the LCIA rules. It says, or exceptionally more than three. So they do actually provide in the LCIA rules for having an arbitral tribunal with, I'm going to assume not four, because you always want an even number for odd number for voting. So that was an interesting one that I was looking at, but looking at pros and cons. And the last thing that I wanted to speak about, because time is pressing, but we're also stalling a bit, I think, for Damian, is to talk about the ICC rules for arbitration. And specifically, the amendment, the expedited procedure that was introduced for, and I think when I said low value during one of the preparatory calls for this, John laughed when I said, I think I actually got the figure wrong, but it was $2 million was a low value dispute as far as the ICC were concerned. And then you have the expedited procedure. Now, I don't know if anybody in this room has had the experience of the ICC expedited procedure. No, good. I have, and actually a member of a panel later was our arbitrator. But it actually works incredibly well, even though we were a German client and regarding a matter in Astan, but it worked for a low value dispute. They've recently increased it to $3 million, and that is a single arbitrator. So that's the cost issue as well, because there is a big cost in the number of tribunal members that you have. Obviously, and just to reiterate the pros and cons that John mentioned, you do have the question about, and I've used to work with a well-known arbitrator in my office, who all the time I would go into his office and he would be going, I'm looking at my diary, I've got to get this arbitrator and this other arbitrator, and how are we going to get our diaries all together, and how am I going to get to Dubai? Nowadays, he lives in Richmond. You can't get him into central London for a meeting, but you can get him to Dubai for a meeting. But then again, that's lunch in London over a trip to Dubai. It's understandable. But it's very expensive. It can be very time-consuming. You certainly couldn't do it in a 28-day adjudication where you're finding multiple people to do it. So those are really pros and cons. No conclusion out of that, but then I think that's what we're going to summarise at the end, and hopefully I've not overrun too much.
Thank you very much, Richard. Seamus.
Good morning, one and all, and Jeremy and John, Richard. I'm going to change it in a slight different direction now, talk about the international point of view, because we've been talking primarily about UK-based. So really, what are the different aspects to international that lends itself? Well, firstly, a lot of international arbitrations are in, obviously, international locations with international parties. So they're completely different dynamics. So because you may have, let's say, a German contracting company that might be against a Korean company. So what then actually happens is the parties need to, respect international arbitration. Party autonomy is really key, because that's where it comes from. The parties that contract internationally. So it's really up to them to govern how the dispute gets resolved. And there's a lot of aspects in that, because they'll have potentially different cultural aspects, they'll have different legal systems and the like. So what they actually do is they want to be quite content that the people that they're investing in the tribunal are good, can actually do the job, can understand where their position is, because, as I say, you need to understand that an arbitration is really only as good as its arbitrators. And the real aspect as well is, given the limited right of appeal in our arbitration, you want to make sure that you've actually got the right people. I mean, and the orthodox view in arbitration, international arbitration anyway, is that you'll have a three-person tribunal. And how that's normally composed, and I'll come on to the rules now in a minute, but how that's normally composed is that you'll have one party will nominate somebody and appoint somebody, the other party will, and then depending on the rules, they'll, let's say the ICC, the president will then get appointed. So, you know, to use a colloquialism, both parties have skin in the game. You know, they're kind of content in the fact that they have people who they've appointed. So they should be more invested into it and therefore give confidence in the process. Now that in itself actually then gives a bit more of a wrinkle in the system, because it has been said and observations made that potentially a party appointed arbitrator or tribunal member might give a bit more credence or try to potentially advocate the position of the nominating party. So there's a couple of issues that you have to be careful with there in relation to that. Bias and sympathy, it said, you know, they may be consciously, they may prefer the party, so they may come off and make many points, but not quite enough just to make it completely warrant their removal from the panel. They may be subconsciously, because they may thinking, you know, again, subconsciously, well, I've been appointed, and so there is that aspect as well. There's also the potential risk that they may feel obliged to make sure they advocate the position that that's put in. And then there's also the issue about their own cultural aspect as well. They may have cultural bias. So there is a concern in that regard. So that's to do with impartiality as well. Now, so I think I've kind of just set out there why international arbitration has three-party tribunals ordinarily. Although the rules, when you delve into them, as Richard says, you know, I automatically think, oh God, they're always going to it's always going to be three-party, but it's not. If we look at the rules, which I had to go and refresh my memory on, there does seem to be a preference towards single-appointed arbitrators, and again, that's probably to do with speed and efficiency, because if we look at the process again, it's difficult enough getting a busy arbitrator to change their diaries if something happens, which would happen during the process. But if you try and herd three people together, or three cats or arbitrators, it's very difficult. I'm just doing an arbitration at the moment as an expert witness, and there's been a little bit of goings on, let's say, between document submissions, and before you know it, the hearing date's moved out 6 months. So that's really, I think, why a lot of the rules do try to press towards a single arbitrator. So, as I say, the London, the LCIA 5.4, sole arbitrators shall be appointed unless the parties have agreed in writing otherwise, or the LCI determines the circumstances of three-party. So again, it's pressing, but I think in my years of experience of working initially as a contracting with international construction companies, a lot of these things are set in the regional arbitration agreement. So when it gets to the likes of the rules, the parties more or less determined what they want anyway. So whilst it may actually be a preference for sole, the parties' requests, again, given the fact that arbitration is at the behest of the parties. If we come to the ICC, again, the ICC is another preference for one. But they can, this is Article 12, where the parties have not agreed upon the number of arbitrators, the court shall appoint a sole arbitrator, save where it appears that to the court that the dispute is such as to warrant the appointment of three arbitrators. So again, one going to three. Whereas the UNICITRAL rules 2021, they take a slightly different approach. If the parties haven't agreed one, then they go to three, which I thought was interesting. The point about in the court system, it's one, and then it goes up to three. So that's an interesting point, because maybe And it's also one of the difficulties with a single arbitrator or decision maker is, well, and especially cases are complex, they may miss something. And if it is an arbitration, the limited rights of appeal, the last thing you really want to do is probably think to yourself, well, God, I should have had 3 people on the panel. It might have been a bit more expensive, but I may not be looking at this, and I may not have had the issues and hassles. I don't know how I'm doing for time.
Another couple of minutes.
Oh God, okay. Well, so, I mean, so we're looking at, as I say, international arbitration. We're looking then at what sort of experience would we expect in a tribunal? Because if we're going to have three parties, three arbitrators, well, you know, would they have legal industry experience? What's their qualification? Is it a common law, civil law? You know, or is one company from, let's say, the United Kingdom, another company from, pick a common law system, France? You know, are we looking at a matter that's quite black letter, or do you want someone who's a little bit kind of propulsive, someone who might be a bit swayed by a good argument as opposed to the black letter? You know, the language of an arbitration, the cultural background. I mean, I just see here there's a note that in the ICC awards in 2020, there was 80% of the awards are in English. Now, it doesn't necessarily mean that the documents were in English, but again, the cultural aspect of understanding what goes on. And again, it's been said, key attributes of a good arbitrator is sound judgment, virtue, reckless ethics, that they're prepared, responsive. And then we get into, I mean, I'm a QS, so it's always very difficult. I mean, I mainly practice in international arbitration as an expert witness. I don't think I'd ever quite make it as an arbitrator because it's packed with so many lawyers. But that's the general sense of what it is. But there are supposedly, you know, categorization. You could have academics, judges, counsel, and experts, and each of those have their own advantages, and some may say disadvantages, because I have heard it said about judges who go from being the master or mistress of all this very into arbitration. It can be a bit of a murky jump for them. But I think in summary, international arbitration, if it's any sort of size of a dispute, does lend itself, albeit given the cost and the potential time issues, it does lend itself to a 3-party tribunal to safeguard against the mistakes that could be made by one person. And that's all I have to say at them. Oh, and so one last thing is about obviously sharing the burden. The aspect is 3 sets of eyes are better than one, supposedly. So, and yeah, that's it. That's it from me. Thank you.
Thank you very much. Thank you very much. Let's kick around some of the questions that have been raised. So far as expertise is concerned, my own experience has been that there's much more opportunity to pull in different disciplines in dispute boards. And on those that I've sat on, I think most of those have involved at least one QS, and very often an engineer with a speciality focused on the particular project. And that's a very helpful thing, which you rarely see in arbitrations. So that's perhaps one factor in favour of a 3-person tribunal. I don't know if the panellists have any views on that.
Well, I'll hold this a lot further away. I was just actually thinking, as you said that, the one thing we haven't spoken about in too great detail, I know it's a topic of dispute boards, where you're actually more likely to find people with multiple different disciplines to assist the parties in obviously watching the project go all the way through, and they have that great understanding. I mean, when I've looked at these, I've actually thought when you're having 3 parties, having 3 lawyers is not necessarily like I say, something mildly controversial, it's almost guaranteeing an argument between three lawyers. Whereas if you have people with different skill sets, they will understand the particular issue and can help one another to come to a conclusion. So I can see a lot of benefits to it.
Yes, I think that's a very fair point. It certainly helps with a more collaborative approach. I mean, generally, unless you have a tribunal where one or more of the members is clearly partial and is trying to help out the party that's nominated him or her, which is relatively rare, generally you do get quite a collaborative approach on the tribunal. But I think it certainly helps if you've got complementary expertise and everyone can bring something to the discussion, which is really useful.
Can I raise one point there? An expert should be able to explain things clearly to one-man panel or not, and there's always a danger of educated people use jargon not to explain things but to show they're educated. And so there is a little bit of concern on my part in that a good expert for me can explain to a lawyer, an engineer, a one-man panel what that position is, where it's particularly, for some reason, planning issues seem to be surrounded by jargon. So I accept that, but I'm always wary of engineer talking to engineer, and I like to understand expert reports when they go in, and I struggle sometimes, actually. So a key point is to get the point, if you've got a one-man panel, make sure your expert can get that across really cleanly. And you should be able to explain that to anybody, whether one-man panel is a QS engineer or otherwise.
Yes, I mean, that's bringing up another point, which is that with many experts, they're very expert indeed on their particular subject, but communicating it to an audience who do not have that particular learning, they find very difficult. And certainly from a counsel point of view, an expert witness who's good on paper and is explaining something simply is very valuable. And if you don't have that advantage, so if you have party-appointed experts who don't have that particular skill, it may be a challenge for the tribunal if they don't have the expertise to understand it. Shall we talk about another issue that you've all highlighted, which is choosing decision makers? And with one, of course, you might be able to agree on the decision maker, particularly at the start of the contract. But if not, there is an element of Russian roulette about the choice of adjudicator or arbitrator from the particular institution, which is the nominating body. With three, however, there's more opportunity for choice, particularly because the parties get the chance to appoint a member each, and then indirectly the parties can influence the choice of chair, because typically what happens is that the party appointees talk about it, and they may well nominate the chair if they agree. If they can't immediately agree, they may try to select the chair by giving the parties lists on a blind basis from which they select. So there's an element of choice there. Do you see that as a factor in favour of three-person tribunal? Richard?
Yeah, I was just thinking while you said that, of experience of arbitration and adjudication where you've got a single party. Obviously, the time scales for adjudication help you to agree adjudicator, because if you put forward someone who's deemed sensible, you're quite likely to find agreement subject to their availability. But in arbitration, when you put forward usually three names, you usually put, in my experience, you put forward the three names of people you kind of almost don't want to have. because you know there's more time. So the other side's going to go, do it like those three. Here are my three. And you go, I don't like your three. And that way you've actually excluded all the people you didn't want. And then you get on to choosing one that you'd like between them. But I think from where it's three parties, and having talked to a few arbitrators about how the process is, it's still, sometimes you feel like it's still the old boy network, or old person network, perhaps you should say now, of people you know that you go to. And so, certainly there are arbitrators I'm sure arbitrators in this room, who don't have to look for work anymore. It comes to them because they have a reputation, they're known, they're going to be chosen. Whereas if there's somebody new coming into the area, it can be quite difficult. So I think, well, we've gone off the topic, but I do think that selecting them three parties is helpful sometimes.
Yes. Seamus, I don't know if you want to add anything to that from the international perspective.
No, I think as I set out there, really, it's an international perspective. It's all about the parties having an input into it, that they're not just beholden to someone who's foisted upon them. That they are quite happy that the case that they put forward will be given a proper examination. So I think the whole process of the three-party permits that. So sadly, for sometimes they don't get the result they hope, but hopefully justice is being done, or, well, as justice is. So that's about it.
Yeah. Now, another factor we've talked about is speed. And with typical adjudication timescales, one can see that a three-person adjudication panel, other than a DB set up well in advance, is very, very difficult. And also with emergency arbitrators, setting up three people as emergency arbitrators really isn't practicable. And in practice, all the institutions appoint sole emergency arbitrators. But is there a scope for sensible discussion between parties at the start of disputes to lengthen time scales and thus allow the possibility of three-person panels? I mean, one can see with a typical ambush, smash and grab adjudication, that's not going to happen. But leaving that aside, is the scope for agreement on more time, which would then allow three persons to be appointed?
Well, just taking it slightly differently, I mean, I've seen in UK adjudications where we talk about it being 1 and 28 days. I've been involved in a couple where they've gone on for 4 or 5 months. I'm not aware really of, in the UK anyway, of having an extended time period to allow three people. It's ordinarily to allow their person time to get ahead of it, because parties normally, even these two parties anyway, were experienced and understood that if they got the right person and that right person could manage the process, then it was better than getting better to have a longer period of time and get a better decision than a short period of time and get a dog's dinner.
Yeah, sure.
And it settled afterwards. So I would find it, and maybe John and Richard, in their experience, whether they've actually found a situation where the period's been extended to permit a three-person.
No. I was, when you're saying that, I was thinking, well, and statutory adjudication, how do you? I know you could agree and try and come to it, but I just can't see anyone in adjudication doing it. But it's in arbitration. I was actually thinking on the earlier question as well, one of the key things with nominating of parties is, of course, you will find, and Seamus mentioned this, you will find common law arbitrators being appointed and civil law arbitrators being appointed, because parties prefer to have people for their own particular area rather than the law necessarily of the contract. But back to the point, I can't imagine in my mind, I can't actually imagine doing it, holding back an adjudication because it's only interimly binding to appoint a three-person panel.
Yeah. One of the difficulties, of course, is that at the moment there is a serious dispute. It's difficult for parties to agree, what day of the week it is. So possibly one of the take-home points about this for anyone involved in the transactional side is don't allow the dispute resolution provisions to be the midnight clause. Make sure it's set up in advance with what your particular party wants. Because if there is a dispute, it's going to be very difficult to agree anything.